A word to the rest of the council and to the members of the public who have been following criminal justice reform over the last couple of years. While it may be true that the reform measures in the area of recidivism reduction and reentry are not this year as data-driven as they have been in the past, that I simply want to caution the public to glean too much from that, because in the end of the day, I think these are very meaningful, and they are to some extent data-driven recommendations. This year's council is built a little differently without the technical assistance providers that we've had in the past, and to that end, I also want to applaud the work group and the council as a whole and the governor for seeking the assistance of Dennis Schranz, who has provided invaluable services to us in building what we think is a very meaningful 5-year strategic reentry framework that this council has adopted earlier today and will be included in the report. So Henry and Paul, thank you for your work in your committee. These are all very, very important and I think thoughtful consideration. And I also would be remiss if I didn't point out that the 5-year strategic plan that we have adopted and that we hope the legislature will adopt is going to, in and of itself, produce a significant amount of meaningful data to determine the effectiveness of prior enacted public policy reforms. And so that's kind of a good dovetail, I think, into, if you want me to present the recommendations from the Oversight and Implementation Committee, I will do that at this time. Again, knowing that we are now on the 3rd iteration of criminal justice reform, public policy changes in Georgia, and recognizing that the 3 bills that have passed are now in various stages of implementation, the governor and this council all thought it meaningful to consider not just simply moving forward to the next round of criminal justice reform, but rather to give great consideration to effectively administering, implementing, and overseeing the criminal justice reform efforts of the past. And so to that end, we have a oversight and implementation work group that has been meeting regularly, that has been working with technical assistance providers from the Very Institute of Justice on the adult side and the Annie E. Casey Foundation on the juvenile side to build performance measures to address all of the public policies that were identified in the bills through the last 2 years, so that in the end of the day, ultimately, the state, the citizens of this state, the taxpayers of this state, and all of the stakeholders that are interested in criminal justice reform in the adult and juvenile arenas will have something meaningful to look at with respect to data to determine the effectiveness of these policies. So to that end, I want to report on the work and the recommendations of that committee, and I'll start with Jill Travis, Legislative Counsel, to discuss a couple of cleanup matters from years past that we're going to, we hope to include in our report. Jill?
Okay. House Bill 11.
Push the button.
Sure. House Bill 1176 passed two sessions ago, and one of the things that was done in House Bill 1176 was to divide up punishment for drug offenses into the quantity of drugs that were involved, and some definitions were involved in that dividing up how you're going to measure liquid drugs versus solid drugs. And a definition needs some cleanup, the definition of solid substance. As we go forward, people working with it have discovered that it could use a few more words to describe the area, and so that's one of the corrections that needs to be done from 1176. Another thing that House Bill 1176 did was deal with accountability courts and put some standard performance measures for the accountability courts that we have in the state presently, and by that I mean that are legislatively created. Those are drug courts and mental health courts. It has come to the attention of this committee that veterans courts is another area that needs to be addressed, that there's funding available for those kinds of courts, and the best thing to do would be to create the avenue for the various courts to have a division of veteran courts and take advantage of the federal benefits that are available for that. So that's another aspect that comes out of House Bill 1176. House Bill 349 was passed last year, and one of the things, again, related to drug use and possession of drugs, greater quantity of drugs, was some changes that were made to the trafficking laws. And one of the things that is a crime that has some mandatory minimums, and the legislature determined that there might be circumstances where a judge might want to go under a mandatory minimum if a variety of circumstances were met. But that if that actually happened, the idea was that sentence would be served in full, that would not be a parolable offense. When the drafting was done for that change, there was an oversight in making it so that all trafficking convictions could not be paroled, and that was not the intent at all, and so that correction needs to be made as a result of House Bill 349. The last one is House Bill 242, which is the Juvenile Code rewrite, 232 pages, and somehow or another there's a few mistakes in there. And I don't have the specifics on those, but I do know that there's a little bit of cleanup that has to come out of that large bill.
Thank you, Jill. Questions of the committee concerning the housekeeping provisions of our recommendations? You have these in front of you as well. Any? KJ.
I have a quick question about House Bill 349 and the all trafficking offenses. Is this just human trafficking or is it drug trafficking? Just drug. Okay.
Yeah, no.
Yeah, just drug trafficking. All right, I'll entertain a motion.
Second.
Any opposed? All in favor?
Aye.
All right, fine. Those will be included in the recommendations to the report. Second, I want to thank the Annie Casey Foundation for their couple of years now that have been in Georgia, and both the Vera Institute of Justice as well, and the Pew Center on the States, and particularly the Public Safety Performance Project for their work in helping Georgia build performance measures, those tools that will be necessary to determine the effectiveness of House Bills 1176, 349, and 242. It's very important, I think, as a former legislator and as a member of the council for the last 3 years, to ensure that the legislation that gets passed is not simply passed and then left to implement itself. We have had tremendous support and wonderful collegiality with DJJ, Department of Pardons and Paroles, and with the Department of Corrections in building a performance measurement model that the council members have in front of you. They're on two separate pages. One is titled HB 1176 Performance Measurement Summary, and the other has no title but is the Juvenile Justice provision. And in short, we'll start with the adult piece. What Vera has done with the assistance of the Department of Corrections and members of the council who have been meeting privately with them and the work group, identified areas of public policy changes that were identified in HB 1176 and articulated those in the left-hand column as to what were the policy areas that we attempted to effectuate, what are the goals of those individual policies, and how might you measure those. Ultimately, with the end goal being, are we implementing those in a strategic and efficient manner? Are we identifying in an early fashion legislative, statutory, regulatory impediments or barriers to successful integration and implementation? And then ultimately, we build these measures so that we have data to demonstrate to what extent, if any, these recommendations are generating the results we expect. One of the expectations that we had in passing 1176 was that we were attempting to slow Georgia's projected 8% prison population growth, and in so doing save approximately $264 million, expand accountability courts, implement evidence-based practices, allow for graduated sanctions to be imposed by probation officers throughout the state. And each one of those particular policy goals is identified on this performance measurement summary. There's been a lot of work that's gone into how do we measure those goals, and I think everyone's had input. If you haven't, we're certainly welcome and interested in hearing your input, but I present to you those performance measurement summaries and in the adult arena, and before we vote on those, we'll vote on them together, I suppose. You'll go to the second page, which is the juvenile justice performance measures. And again, likewise, Annie Casey has gone through both bills, 242 and 349, and identified the public policies that were attempted to be addressed in those bills, and those include everything from creating a two-class designated felony system to prohibiting status offenders and some misdemeanor offenders in the juvenile arena from being placed in costly facilities, some performance incentive structures, structured decision-making tools, a reinvestment strategy that would incentivize local communities to treat juveniles in their community as opposed to in these facilities. And as we identified each of those, we then decided how do we prioritize those policy goals? How do we measure those policy goals? What are the performance measurements and the outcomes that we're expecting? And so again, I thank Annie Casey, I thank Vera and Pugh for all of the effort they put together in building these performance measurement models. And I think it is important that this council include those performance measurement models in the recommendations we make to the General Assembly, that they be adopted. So any questions concerning the performance measurement models for adult or juvenile? We have folks from Annie Casey, I guess, and
Yeah, they're on the phone, so if you have any in-depth questions for them, Judge?
On the adult performance measures, I had two concerns. We sort of debated this, and I certainly defer to the wisdom of the group. One was on the electronic sentencing packets and the time between the date when the sentencing packets were received and the days between sentence and prison transfer.
Right.
I think we've discussed that we pretty much have accomplished that goal. Almost everybody submits sentencing packets, and so I don't know that we want an ongoing performance measure because it's not going to get any better. The sentencing packets are, now that we got everybody submitting the packets, it sort of takes care of itself. So I think we just need to keep that in mind.
Well, I would go ahead and move that we eliminate that as a performance measure.
Well, hang on. For purposes of discussion then, since you've got a second, let me simply say, and I haven't talked, this is the first I've heard of the concern, and I think it's a legitimate concern, but I still think it's important that we measure it to the extent that it gets worse. We may need to understand why and may be able to implement strategies that prevent that. I mean, indeed, it seems to be quite successful. I think everybody's on board. All 159 counties, I think, are now on board, and I know that the jail backlog with respect to this has lessened. But I don't think we don't track it just because we've met that benchmark so far, because I think it's important that we continue to keep our eye on it. There may be some unintended consequences there that we ought to keep in mind. It'd be the only reason I say that.
Perhaps the measurement ought to be the time from the time it's transferred to the state and when they pick them up to go to prison.
As opposed to between the sentence and the prison transfer.
Because
sure,
we have no control over how long it takes the clerk to transmit it to the state.
I think that change is appropriate.
Okay. I would move to make that change. And how would you like that to be read, Judge Steele?
If we're going to measure that area, I think it should be the days between the day between transfer of the sentence to the state and prison transfer. The other issue I had was on the next to last one, graduated sanctions. As you know, we adopted a PALM system in the state. It is a voluntary system. Some court systems use it, some others don't. For instance, my jurisdiction, we don't use PALMs. And so I don't know that measuring the number of courts using PALMs is a good measure to make when it's not mandatory, and there are some jurisdictions that say we feel like, my jurisdiction, we feel like the judge ought to handle probation revocations versus deferring to someone else. So I just don't know that you're going to see any movement in that area because there's no incentive for the different jurisdictions to adopt PALMs. Does that make sense?
Yeah, I mean, my former circuit didn't use it either, but I think that the question as to whether they're properly incentivized really goes to, it's driven by workload, and I think many of the decisions that circuits have made to use PALMs has been driven by the fact that they're sitting superior court judges and they have limited resources to use senior judges. You're really limited on how quickly you can get to probation revocation cases, and of course that drives up your jail costs because your sheriffs are having to house these people, typically on probation violations without bond, waiting on that revocation hearing. There are a myriad of other issues that I've had, but nonetheless, I don't know that in the future there might not be some more movement towards, I know corrections is still very high on the program, and I am too. I think that there are a lot of programs like that in the state that are working very well. It may very well be that as we change, we have a younger group of judges coming on the Superior Court bench, we have different thoughts, maybe there will be some incentive to start using the program. It ought not be used simply because of time constraints, but that is one of the incentives.
I guess maybe my thought is that if you didn't use the first two performance measures, courts using POMS or cases sentenced to POM, then you get out of the decision of whether the system's going to use it or not. You can still measure the number of cases diverted from court calendars.
Sure.
And the number and type of positive responses, because that shows that the POM system is working, which perhaps would then lead other folks to utilize the POM system. That's
Which would get you back to still wanting to include courts using POM in cases sentenced to POM.
just my 2 cents. I don't know that you're going to see a tremendous move on that performance measure, because it's not like the other issues like the accountability courts where there's an incentive to open those and to make them work.
Sheriff, do you have a comment?
I think everybody's addressed mine. Thomas, in sake of brevity, I won't repeat everybody else.
Any other questions?
So I'm prone to do.
Good questions, Judge. Thank you.
Okay, Joe.
Quick question about the courts using POM. So are we saying that the more courts that are using POM shows the more success of 1176? Or is it?
I think that we're trying to develop a measure that shows that POM is actually working, and using that measure, if it goes the way we think it's going to go, to incentivize other courts to use POM. And I think to Judge Deal's point, saying how many courts use POM really isn't going to have any bearing on that decision, and doesn't have any bearing on what's working, on whether or not that's working. So I would move to edit these performance measures to reflect on electronic sentencing packets that days between sentence and prison transfer be edited to days between transfer of sentence to state and prison transfer. And then, Judge Boggs, do you want to weigh in on the?
But yeah, before we amend the performance measures on the graduated sanctions POM program, I think, Katie Jo, to answer your question, you have to go back to the policy goals that we're trying, in column 2, that we're trying to gauge here. If judicial efficiency was one of the goals of 1176, and particularly the goal of the implementation of graduated sanctions, and another was that we focus resources on high-risk offenders, I think the POMS program obviously is a measure of that, because we allow judges to not have to deal with these technical violations of probation necessarily, and we allow probation officers to do that as approved by and authorized by the judge. And so measuring the courts using POMS and the cases sentenced to POM, while I agree with the judge that we're likely not to see a huge increase in that, to the extent we see any increase, is that effectuating and helping us reach our policy goal of judicial efficiency and focusing resources on high-risk offenders. And I would argue that it is, although I'd agree that you're likely not to see a huge increase there, but I don't think it's going to be very troublesome to include that as a measure. It's certainly not detrimental to fulfilling our obligations. And so I would suggest we don't edit it, but I respect that it's probably going to be one of those performance measures that doesn't tell us a whole lot. But to the extent you see some movement there, it is an indication that we are maximizing judicial resources, I think, which is a goal.
Then my only motion would be to edit the electronic sentencing package language.
Second.
So as edited, a motion that we accept these performance measures in the juvenile and adult arena.
So moved.
And a second?
Second.
All in favor?
Aye.
Any opposed?